All rise, huye bouleve. The International Criminal Court is now in session. Lord John Court Penal International at the wait. Please be seated. Huye bu eswa.
Yes, good morning, everybody. Could we have the case called, please?
Good morning, Madam President. Good morning, Your Honours. This is the situation in Darfur, Sudan, in the case of the prosecutor versus Ali Muhammad Ali Abd-Al-Rahman. Case reference ICC 0205-120. And for the record, we are in open session.
Yes, we'll start with the appearances for the defence. Mr. Lachi, I don't think we need everybody's bar this morning.
Bonjour Madame la Présidente, bonjour Mesdames les juges, bonjour chers collègues. Aux côtés de Monsieur Ali Mohamed Ali Abd-Al-Rahman, présent dans la salle ce matin, nos stagiaires, Mesdames Claire Chauffard, Pénélope Fourès et Salomé Fischer, les assistants juridiques de la défense, Eva Kalb, Nina Guillou, Ahmad Issa, Anine Khali, Marcella Velarde et Camille Divet, la conseillère juridique de la défense, Madame Audrey Matteo, mon confrère Yann Edwards et moi-même, Cyril Lauchi, du barreau de Marseille.
I should never have tempted you, Mr. Lachi. Yes, can we have the prosecution, please?
Morning, Your Honors. Morning to everyone. Same as yesterday, but we are joined by Mr. Santana. Thank you.
Yes, thank you, Mr. Nichols. And finally, the representatives of the victims.
Bonjour Madame la Présidente, Mesdames les juges, chers confrères. Les victimes sont représentées aujourd'hui par mon confrère Anan Shah, mon gestionnaire de dossier Saïf Kassis et moi-même Nathalie von Westinghausen du barreau de Berlin.
Okay, everybody, I know it's the last day, but even so. Yes, thank you very much, Ms. von Westinghausen. Yes, Mr. Edwards.
Good morning, Your Honours. After having completed a brief tour of the horizon yesterday relating to the question of credibility, it was by no means comprehensive. I turned to submissions on the three crime scenes of Kuruman Bindisi, Mukjar, and Deleg, and we'll take those in turn. Can I start with one point, and it's a point that is of relevance to all three of the crime scenes. It is the defense case that Mr. Abd-Al-Rahman was not present at any of these crime scenes at the material time. He's not Ali Kusheb. Whether or not a person called Ali Kusheb was present or not, we do not know. All that we can say is that Mr. Abd-Al-Rahman was not. Senior counsel for the prosecution the day before yesterday regaled us with an anecdote of the four-dog defense, comparing it to our multi-layered defense in his description. Mr. Lauchi will, a bit later on today, address you in detail on the different lines of defense. But suffice it to say that, yes, we unashamedly and vigorously advance the defense that Mr. Abd-Al-Rahman is not Ali Kusheb, and he certainly wasn't known as Ali Kusheb in 2003, 2004. But as we say in our brief, and as we have been saying for a little while now, he has inevitably become associated with the sobriquet Ali Kusheb through no fault of his own and against his will in recent years. That question has always been, remains a hotly contested matter between the OTP and the defence, and it's a matter that Your Honours will have to decide. We know how we hope that Your Honours will rule. We know how we think Your Honours should rule in light of the totality of the evidence. But we, of course, as Mr. Abd-Al-Rahman's defence team, have to make provision for all eventualities. We have to acknowledge that although it would be surprising, Your Honours may find that Abd-Al-Rahman is and was Ali Kusheb, and it would be supremely unwise, Your Honours, if, as a defence team, we placed all our eggs in one basket. I apologise, I've no idea how that's going to be translated into Arabic. So it's the most natural thing in the world, you will understand, to have prepared the ground based on the evidential record for subsidiary, for alternative lines of defence. It doesn't amount in any way to a concession that that a finding by Your Honours that Abd-Al-Rahman and Ali Kusheb is the same person, that would be a correct finding. But whilst we hope for the best, we have to prepare for the worst. And we're confident that Your Honours understand that. We're quite sure that the prosecution understand that as well, notwithstanding the studied bewilderment on the part of the prosecution the other day. And we know that you will not approach our multi-layered defence in a way that is held against us, but most importantly, not held against our client. Any finding that Mr. Abd-Al-Rahman, as Ali Kusheb, was present and criminally responsible for the crimes committed at the three crime scenes would have to be a finding made on the basis of your being satisfied of that beyond reasonable doubt. We say you cannot be satisfied beyond reasonable doubt because the evidence, looked at holistically, does not permit of such a finding. The evidence in respect of each of the crime scenes and in respect of each of the individual charged crimes and in respect of each of the modes of criminal responsibility alleged by the prosecution is simply not strong enough, we say. Now, as far as Kudum and Bindisi is concerned, as I hope we've been clear since the outset, the defence do not dispute that the attacks on Kudum and Bindisi actually occurred. The evidence that the attacks occurred is made out, and the evidence that innocent civilians were brutalized, killed, beaten, raped, that homes were burned and pillaged, and that civilians were forced to flee. These crimes, these terrible crimes occurred, innocent people suffered, and the defense for Mr. Ali Muhammad Ali Abd-Al-Rahman do not dispute that. Similarly, we don't dispute that men were arrested and detained at Mukjar and Delej and brutalized and later executed. We accept that. We genuinely sympathize for the victims, the families of the victims, and with the victims' communities more broadly. But our case is actually quite simple. Awful as the crimes were, they cannot be laid at the feet of Mr. Abd-Al-Rahman. He wasn't present. The evidence does not create a link between him and the charged crimes, and that's why he must be acquitted of all 31 counts that he faces. So, what of Kudum and Bindisi? Well, we say that the evidence is riddled, Your Honours, with contradictions, inconsistencies, implausibilities, and indeed evidence from untruthful witnesses. And that these difficulties in the evidence cannot be reconciled in a way that would permit Your Honours to be satisfied beyond reasonable doubt of Mr. Abd-Al-Rahman's guilt in respect of the crimes of Kudum and Bindisi. Your Honours wanted to, one of the questions that Your Honours asked of the prosecution related to documents D and E in question. I'll just bring it up. I'm not going to say anything identifying about the documents, but it's question 6. and documents D and E, the documents that relate to the destroying of Brindisi. Now, the prosecution addressed these letters on Wednesday. We say that the story of how the source of these letters acquired them is frankly ludicrous. If it weren't so serious, the account would be laughable. And Your Honours will, it's so memorable that, of course, Your Honours will recall the circumstances. It's one of the standout features of this case because it's frankly so bizarre. Now, the prosecution have attempted valiantly to persuade you that the source's explanation for how he came to be in possession of these scraps of paper is a good and reasonable one. But we say that the explanations don't begin to survive the slightest scrutiny. If the truth is that the source wanted these documents, surely the most straightforward, the safest and quickest way of securing these documents would have simply to have been to take them. I won't say anything about the year, but the source's evidence as to when he saw these documents was several years after the time at issue. These letters were no longer of any relevance because they related to something that was back in history. There's no reason to think that they would have been in any way missed, or at least not right away. Your Honour will recall the way in which the witness said he secreted the documents away. And I ask rhetorically, how is it that he couldn't have done exactly the same thing in respect of the originals? The way in which the documents were secreted away, he says, is, or one can infer, to minimize the chances of them being found, because if they were found, even copies, he would get into a lot of trouble. Well, exactly the same point can be made about the originals. He would have been at no more and no less risk of serious punishment. His explanation for the scrappy version that Your Honours have seen simply makes no sense. The prosecution on Wednesday said, well, bear in mind his background, what he's trained to do. True bill. The documents are fabrications. Now, the reason why I've dwelt on these letters for a moment is because they're the genesis to to Ali Kusheb's involvement in Brindisi, the link between him and the Brindisi operation. If those letters go, that goes a long way to the crumbling of his connection with the Brindisi operation. I'll turn now to the zakat letters. Details of where this letter came from, who wrote it, to whom it was delivered, is not without its inconsistencies. If I talk about the three insider witnesses relating to the Kudum and Brindisi operation, I'm sure you'll know who I mean. But they couldn't get their story straight about the letters. Two said that the letter was signed by Abd-Al-Rahman. Another said it was by Torshain. Anyway, paragraph 389, Your Honour, of the defence brief, we deal with that. There's some confusion about whether it was Hemedan who handed the letter over or Ali Kusheb. a mass of contradictions, of inconsistencies. Why? Because they're not recounting a true story of what happened. There's one quite remarkable inconsistency that's difficult to resolve. It may sound like a small matter. It may sound like it's not that important, but I suggest it is very important. It's this, that Ali Kusheb's alleged mode of transport during the Kudum and Bindisi operation, or at least at the very beginning. I want to stay in open session, but there's one of the insider witnesses said that Ali Kusheb joined the convoy some 3 kilometers away from Mukjar on horseback. But that's not what the other witnesses said at all. They said that he was in a vehicle. Now, where would that inconsistency come from? It's difficult to resolve. It's difficult to understand how one could be confused about seeing somebody on horseback on the one hand or in a car on the other. A second insider witness testified that he, Ali Kusheb, Sameh, Shukrullah, and the first insider witness departed the CRF base in Mukjar in 2 vehicles, saying that he didn't actually know Hasabala or the third insider. And the third insider, for his part, says that Ali Kusheb and he departed from Mukjar in only 1 vehicle, with the first insider and 3 guards, Daoud Dahab, and a driver. The first and third insiders don't mention the second. It's a mess. It's chaotic. And why is it a mess? Why is it chaotic? Because it's a fabrication. I briefly mentioned yesterday that I'd give you cites to what we have to say about the credibility of the third insider. Time meant I couldn't deal with it in the way I wanted to yesterday, but our brief, paragraphs 363, 388 to 395, and 403. And in short, our position with regard to that witness is that his testimony is worthy of no credit whatsoever. What do we know of the beginning of the operation? Well, we know that the villages of Nieli and Tiro were already in flames before the arrival of the convoy and the insiders, which must place a huge question mark over the issue of which force, or which forces, and more importantly, whose forces were responsible. The trial chamber, we say, cannot exclude the possibility that Nieli and Tiro were attacked by an unrelated group, another group, under someone else's orders. One of the insiders posits that Ali Kusheb spoke to Bonjous and Sameh and was coordinating those early accounts. But our submission is that evidence is simply not as clear as the prosecution would have you believe it is. That insider says he didn't hear what was being spoken about on the phone when he saw Ali Kusheb speaking on a phone. Certainly couldn't understand clearly what was being spoken about. And here I'm looking at transcript 80, pages 49 to 50. And we say that his evidence in that respect is largely speculative. What is clear, however, is that various persons in positions of some authority, Bonjous, a Janjaweed commander, Daoud Dahab, Anumda and Mujahideen Emir, Hamouda Hamdan, the Agid al-Ogada in Bendisi, Sameh, another Janjaweed leader, Hasabala, all were present and implicated in the attacks on Kudum and Bindisi. We've lost the live note. Have your honours lost the live note?
In fact, just sent a message to say nothing's happening.
All right.
What's going on? Well, that's great. What does that mean? may have heard that they're working on it. An unspecified time, but a few minutes apparently.
I'm in Your Honour's hands. I'm happy to crack on, but
Well, I mean, I assume they're still taking notes. I mean, I'm still taking notes. They're still recording.
yeah.
It's just that we can't get it up. Yeah. So I'd carry on, Mr. Edwards.
So, since we dispute that Ali Khrushchev was even present at the scene of the crime crimes in Kudum and Bindisi, the crimes would clearly have been committed anyway, but by virtue of the presence of authorities that absolutely could have led the attacks in precisely the way that they were committed. And his presence is not necessary as part of the narrative. The prosecution do not, as we understand it, because they cannot argue that but for the presence of Ali Khrushchev, the crimes in Kudum and Bindisi would not have occurred. His presence is therefore entirely superfluous, and that goes a long way to demonstrating, or at least providing indicia, that his presence is a fabrication. He wasn't there. He gave no orders to anyone, and he did not induce anyone. The prosecution make great efforts to highlight broad consistencies, the broad overlap of evidence between their witnesses. And they say that, well, because they broadly say the same thing, our case is based on a solid foundation. Well, superficially attractive perhaps, but we say the devil is in the detail, Your Honour, because that is where you, as triers of fact, will analyse the evidence to a more granular level. That is where the inconsistencies between insider witnesses, in particular, and contradictions in their accounts become ever clearer. And that's where doubts about their reliability become increasingly evident. And realistically, inconsistencies, contradictions can come in all manner of different flavours. That there may be the, as it were, the so what inconsistencies, the who cares contradictions. But that's not what we have here, for the most part. For the most part, the contradictions and the inconsistencies and the implausibilities are of significant importance. And we set those out in some detail in our brief. Now, the prosecution, if we just take a step back, the prosecution are asking you to convict Mr. Abd-Al-Rahman for these most serious of crimes, the most serious crimes known to humanity. If you find that you have no reasonable doubts about the prosecution's case, then, well, yes, of course, you will convict. But we say that the combined weight of the contradictions and the inconsistencies, specifically between these insider witnesses, whose evidence it is that really makes the link between Mr. Abd-Al-Rahman as the alleged Ali Khrushchev and the crimes, as the link between him and the crimes, we are quite confident you will ultimately conclude that the combined weight of those contradictions and the dishonesty and their untruthful denials of their own implication in the crimes of Kudum and Bindisi, all of that combined injects more than reasonable doubt into the equation, and that will leave Your Honour and Your Honour's colleagues with no choice but to find that Mr. Abd-Al-Rahman is not guilty. On Wednesday, the prosecution spent a great deal of time frankly just repeating the narrative of Kudum and Bindisi and explaining how it unfolded and repeating its case and putting their case at its highest without really grappling with the myriad contradictions and inconsistencies that we identify in the brief and that we continue to rely on. But your honours won't have that luxury. Your honours won't have the luxury of sweeping those problems with the prosecution case under the carpet. You're going to have to deal with it. And we say that having dealt with it, you will arrive at only one conclusion. Final topic I want to address before we move on to Mukhtar is what Mr. Jeremy finished on Wednesday. The mens rea of Ali Kusheb with regard to counts 8 and 9, rape, Your Honour's question 20. A great deal of time was spent in the prosecution's submissions and indeed in Mr. Khan's opening on Wednesday about the profoundly negative impact of rape on the Darfuri community. We don't dispute, I reiterate, that rapes occurred and that other forms of sexual and gender-based violence occurred in Kudum and Bindisi and indeed elsewhere in Darfur. We don't dispute for a moment that its consequences on the lives of victims and on the community more broadly are enormous, and that tragically the consequences don't just stay with the victim, that it has consequences that are intergenerational. But with great respect, none of that is of relevance to the question of Mr. Abd-Al-Rahman's individual criminal responsibility for rape as alleged in counts 8 and 9 and his responsibility for having ordered and or induced rape. You're going to have to be satisfied beyond reasonable doubt that even if Ali Kusheb did utter the words, Aksa Amsa, cut the straw, eat it raw, and so on, that it was foreseeable that in the ordinary course of events, rape will be committed. Not will, with absolute certainty. I don't put the bar that high. The prosecution in the litigation on the judgment for acquittal, transcript 114, pages 75 and 76, quite rightly said that the absolute certainty test is not the one to be applied because that would be impossible. But the test is will with virtual certainty. And, Your Honour, we urge you to reflect on that standard for a second or two, because it is a high bar. It is a higher bar than the test that the prosecution advance in their brief at paragraph 383 of Wood. The prosecution's argument that he was aware that rape would be committed in the ordinary course of events, should be will, but there it is based on the vaguest of generic factors that are simply not supported by the evidence, we say. Astonishingly, one of the witnesses that the prosecution rely on is P547. I would urge you, we would urge you to go back to the transcript of 547's evidence. It's a transcript 52 from page 81. He was answering questions from Her Honour Judge Alapini Gansu in general, not specific terms, that killing, rape, looting generally took place in the field. And Ali Kusheb, as a Forsan commander, like the others, would have a responsibility for that, would be aware of that. But the witness had no specific knowledge of Ali Kusheb at all. he did not know, he could not have known what was in Ali Khrushchev's mind in 2003 and 2004 in general, and certainly not on the 15th or 16th of August of 2003. They didn't know each other. They'd never met. Paragraph 385 of the prosecution brief, they make reference to rape being a consistent feature of government of Sudan counterinsurgency campaigns, and that Mr. Ali Muhammad Ali Abd-Al-Rahman had taken part in such counterinsurgency campaigns in the south of Sudan in the past. Well, that's grasping at straws, we say. That the prosecution has provided no evidence that rape specifically occurred systematically or at all in the context of the activities of Mr. Abd-Al-Rahman during his deployments in South Sudan. And frankly, they ignore the fact that for the vast majority of his time in the army, he was a nurse, a medical assistant, not a combat soldier. So one understands why they try to make the link, but they're grasping. Paragraph 386, the prosecution rely on the fact that rape occurred in villages attacked prior to Bindisi. But we say, where is the proof that permits you to find beyond a reasonable doubt that he did know about rape occurring in villages attacked prior to Bindisi? We say that that is purely speculative. There is nothing in paragraphs 387 to 391 to prove beyond reasonable doubt that he knew that rapes will be committed in the ordinary course of events. And I refer to our submissions made in paragraphs 431 to 439 because they set out the factors that Your Honours have to take into account in terms of what fixes him with the requisite knowledge. Haroon's speech, what was said on the night of the 15th of August, and so on. And we set out the factors that inject significant doubt. One final point is the context of how you should find the terms Aqsa Amsa and how those would be used and understood. And with great respect, it's deeply unhelpful for the prosecution to rely, to refer to and rely to jurisprudence from the Taganda trial judgment in support of their position. What words were used in the context of a different armed conflict at a different time in a different country involving different actors doesn't help, Your Honours. The way in which Aqsa Amsa and Cut the Straw and all the rest of it would have been used and understood in the context of Sudan, in the context of Darfur in 2003, 2004, in the context of Arabic as opposed to Swahili. That's what you have to look to. It is a supremely fact-specific exercise. And looking at case law, it's a misuse of case law. I would submit it's certainly hopeless. The legal approach, however, not the fact-specific, but the legal approach that we submit is relevant and of use in your assessment of words of alleged encouragement and inducement is set out clearly and rather neatly in the ICTR Perlich first instance judgment of the 29th of May 2013. This is where...
ICTY, I think.
Did I say ICTR? Forgive me.
Yes.
ICTY, yes, obviously. And in that case... sorry, one moment. I'm not too sure if I can find it, but I think it's the late Pryliak who was said to have used the words relating to the situation in Varesh to show no mercy to anyone. And the trial chamber in that case, not looking at anything particularly fact-specific, but they set out the approach that is useful in law. Paragraph 642. Time is not on my side. I'm going to move on now to Mukhtar with your leave. Paragraphs 155 to 202 in our brief. Again, our case is that Abd-Al-Rahman, as Ali Kusheb, allegedly, was not present at Mukhtar police station at the material time or at any execution site. You would have to be satisfied beyond reasonable doubt to the contrary. And we say that you cannot be so satisfied because the evidence is once again, even looked at holistically, it is simply not strong enough. We submit that the prosecution has failed to establish with sufficiently reliable and credible evidence the existence of a so-called Mukhtar common plan. That's explored by the OTP in their brief from paragraph 477. We say there's not enough there. And there's certainly not enough to establish Ali Kusheb's contribution to that plan. For what it's worth, the case law relied on by the prosecution in terms of a common plan and how to look at questions of co-perpetration is accurately set out, both in terms of and that applies both to Mukhtar and to Delej. The case law in this court's Kilolo case, the decisive consideration for determining whether an accused person must be qualified as a co-perpetrator is whether the individual contribution of the accused within the framework of the agreement was such that without it, the crime could not have been committed or would have been committed in a significantly different way. And that's from Kilolo, that's from the Kilolo case, Appeals Chamber, 8th of March 2018 at paragraph 820. And that more recent case law mirrors the very early case law from Lubanga. The contribution of the co-perpetrator must be essential. Paragraph 999 of the first instance Lubanga decision. With the involvement of the PDF in Mukhtar through Hasabala, the involvement of military intelligence through Hamdi and other SAF, senior SAF members, the OTP has failed to prove beyond reasonable doubt that Ali Kusheb made a contribution that was essential and that without his contribution to the crime, the crimes would not have been committed or would have been committed in a significantly different way. It applies both to Mukhtar and to Delej. These crimes were undeniably dreadful, but they cannot be connected to Mr. Abd-Al-Rahman. I'm just going to focus on one or two matters that are particularly troubling in our submission. At paragraph 492 of their brief, Ali Kusheb is said to have personally arrested Abakar Abdelmullah and to have driven him to Mukhtar police station. He would have been executed a few days later. Now, we address this in paragraph 478 of our brief, but I nevertheless think that it's worthwhile running through some of the facts here and the frailties of the prosecution evidence. The source of this information is 720. We say that he had no reasonable basis for identifying the man he refers to as Ali Kusheb, other than through hearsay evidence from Abdul Mullah. but there's no information as to Abdul-Mullah's own basis for knowing that the person that arrested him was Ali Kusheb. 720's own knowledge, the basis of his knowledge of the execution, is also based on hearsay. He says that Abdul-Mullah, and Your Honour, it's in fact Annex 17 of the OTP brief. It may be worth bringing up now, but at Annex 17 of the OTP brief, we see that Abdul-Mullah is victim number 1. And you see that the footnote 1, we see that the source for the information regarding his death is twofold. P720, as I say, but also P129. Sticking for a moment with 720, well, his evidence, or the basis of his knowledge of Abdul-Mullah's execution, is based on hearsay. He didn't see the loading of prisoners into any vehicle. He says that he and other people had seen vehicles carrying prisoners leaving in the direction of Garcilla, but he didn't see Abdul-Mullah in any of the vehicles, certainly not executed, and he didn't see his body after the execution. Excuse me. But in terms of what we know about Abdul-Mullah coming from 720 and P129, there's a significant and very troubling contradiction. Because P129, the other source, I pause for a moment because I say for reasons that I went into yesterday, we say that 129 is a highly unreliable witness for various reasons. He's a witness who talks quite a lot about children being imprisoned at Mukhjar. But his evidence about that fluctuates over time, and the number of children that were imprisoned in Mukhjar fluctuates over time. In his first account, well, I won't give the year, but it's in his first account, it's DAR OTP 0128 at paragraph 48. He talks about seeing one boy of 12 to 13 years old, and then seeing him again during a second period of detention, but he doesn't know his name. What he does say is that he believes he was subsequently released, but he doesn't know when. Now that evolves so that by 2021, one boy turns into 3 boys. And one of those boys, he says, was hit in the head by Ali Kusheb when Ali Kusheb was hitting an umda. He doesn't give a name, there's no suggestion that it was necessarily deliberate, sort of transferred malice sort of situation, but he provides no name for the 3 boys. And that's at DAR OTP 02200703 at paragraph 58. And then, in DAR OTP 0000086, this turns into 7 children, 7 people under the age of 18. And I don't ask that we won't be able to bring it up, but when you look at 0000086, that's his list. The person that he describes as Abakar Abdul Mawla is between the ages of 11 and 12. So we come back to Annex 17, Abdul Mawla, the 4 victim mentioned by P720, the other source, Well, he's a man who was between 30 and 35 years old, a student farmer from Mukjar, the son of a cattle owner. They're clearly not talking about the same person, although the prosecution conflates this evidence about one Abakar Abdul-Mullah. There's either a mistake, but we say most likely P129 is simply completely wrong. He's either making it up, because that would be consistent with what we see in his evidence about the evolution of his account of seeing children detained and killed. And we say that this is further evidence of P129 making things up, embellishing his account, and fabricating a case against Mr. Abd-Al-Rahman for reasons of his own. We say that this worrying aspect of P129's evidence goes some significant way into throwing his evidence about who he purports to identify, his evidence of who had been arrested and imprisoned at Mukjar, the reliability of his evidence throws it into doubt. We were criticized on Wednesday by the prosecution for seeking to take advantage of a moment of confusion that that witness had, P129, that he experienced with regard to timing of a public speech. And this is at real-time transcript from Wednesday, page 109. And it was said that, of course, we shouldn't be allowed to capitalize on confusion when a witness is reliving traumatic events in the past whilst giving evidence. Now, whether or not it's fair to capitalize on inconsistencies and contradictions when seeking to establish a challenge to credibility, whether that's right or not, what we do submit is that it's a wholly valid point simply to point out to the court that where frailty in a witness's memory associated with trauma is present, that may impact on a witness's reliability of their memory. That must be a fair thing for the defense to explore and to point out. This is evidence that dates back very many years, of course. The detainees at Mukjar underwent the most traumatic of events, of course. Confusing, terrifying, and your honours will know from experience that memories created in times of stress and trauma can present significant reliability challenges. We ask you to take that into account in your assessment of the reliability of the evidence of the detainees, including the accuracy of victims' lists from Mukjar. The same point can be made in respect of Delej. One final thing before I move on to Delej. I just want to briefly touch on the prosecution's case regarding execution sites and a fundamental problem that we say exists with their approach to the order in which executions took place and the number of execution sites. Here we have, from two witnesses, two accounts that cannot be successfully understood, looked at together. In their submissions on Wednesday about execution sites, the prosecution refers to the first execution site near the sycamore trees. That's fine. The next site is referred to at paragraph 454 of their brief. I want to stay in public session, so I won't identify the witness, but this is the evidence of the killing of the sheikh and 7 children. That comes from a single witness, and that's a witness whose credibility is very much in issue. His evidence is uncorroborated. a survivor witness identified in the title above paragraph 456 in the OTP's brief says that the convoy moved on from the second execution site to the third and final execution site. But that survivor witness says nothing about the execution of the sheikhs and the children. He says, and the witness of the execution of the sheikh and the children says nothing about the supposed third execution site. But they're driving in the same convoy. There's no evidence that one part of the convoy at any point peels off. See, for example, transcript 88, page 73. And we say that there's no explanation that stands up to any scrutiny that the survivor witness would not have observed the killing of the sheikh and the children. Yeah. And the survivor witness is a witness who, Your Honours will remember, provided a great deal of evidence. He had a remarkable ability on the face of it to remember details such as the precise words spoken by Ali Kusheb in the convoy. He gave a great deal of evidence that the prosecution asked you to accept, and yet it's just irreconcilable, we say, with his failure to give evidence of the murder of the sheikh and the children. And the conclusion, the consequence of that, we say, is that the killing of the sheikh and the 7 children simply didn't happen. The OTP can't reconcile these difficulties, and they make no persuasive attempt to do so. I've only got 10 minutes left, so I'm going to move on now, I think, to... I was just going to say that in our brief, we refer to the authorities that were in Mukhtar. Al-Jili, the commander of the police in Garcilla, Al-Taib, the head of the CRF and the head of the Mukhtar police station, that these were authorities that were in a position to give orders to carry out the crimes, and their presence, their authority makes it less, not more likely, that Ali Kusheb had no role to play and that he's not guilty under co-perpetration for the reasons set out in what we say about Kilolo, in the cases of Kilolo and Lubanga. Right, very briefly, Delej. Full submission set out in our paragraphs 560 to 663, and I'm not going to repeat those here. Suffice it to say, our case is that the prosecution's case with regard to Delej is replete with contradictions and inconsistencies. Beyond the most superficial assessment of the story, once Your Honours scratch below the surface, you'll see that the OTP has failed to present a clear and convincing narrative of what transpired in Delej. Specifically, we say a reliable narrative in terms of the role played by Ali Kusheb. You've been given, really, an incoherent and fragmented patchwork of information about dates, about time frames, about perpetrators, about sequences of events. And it's inadequate if you're going to be asked to conduct a full and fair assessment of the evidence, and if you're being invited by the prosecution to find Ali Kusheb's doubt beyond reasonable doubt. And our client, Mr. Abd-Al-Rahman, must benefit from that doubt. Very briefly, there's one point in the time that I have left that is worth raising for Your Honour's consideration. Paragraph 397 of the prosecution's brief makes reference to the fact that the Sindhu convoy, consisting of Abd-Al-Rahman, should be Ali Kusheb's vehicles, 700 to 800 militia. Putting it in the most neutral and understated way, of course, it's an issue in this case between the prosecution and the defense that Abd-Al-Rahman was a Janjaweed leader. But it's a remarkable fact of this case that despite calling a number of insider witnesses to try and establish Mr. Abd-Al-Rahman's leadership within the Janjaweed, including a number of witnesses who accept no liability for their own actions, even though their responsibility, their criminal responsibility is absolutely clear. It's remarkable that the OTP has not called a single militiaman. There has not been a single Janjaweed accomplice witness. And you'll know that at the ICTY and the ICTR, these were often the most significant, the most important witnesses. The Abd-Al-Rahman, the Bosnian Serb soldier, for example. There isn't a single Janjaweed called by the prosecution to testify to say, I saw Ali Kusheb, I heard Ali Kusheb, he was my leader, he was the one who ordered me and my brother Janjaweed to commit crimes, and we obeyed, and we knew what Aqsa Amsa meant, and we knew what cut the straw and eat it raw meant, and we heard it and we understood it. There is no reliable evidence of the so-called Delej common plan, and the Kilolo and Lubanga tests applied just as much to Delej as they did to Mukhtar. Hamdi, he was involved, he was there, he was senior, he was arguably in a position of seniority as compared to Ali Kusheb. Through P994 and P883, it said that Hamdi wasn't present at Delej police station. 643, however, says he was, that the police station was managed by Hamdi after he took the keys from Juba Hassan Fadali, the chief of the Delej police station. And thereafter, Hamdi was the boss, the manager. It was Hamdi, with Ali Kusheb, who removed the detainees from the jail, had them lie face down in the open area in front of the police station before having them driven away to be executed. The prosecution cannot say that Ali Kusheb played such an important role that but for his presence, but for his orders, the crimes wouldn't have been committed. The search and arrest operations. Well, the prosecution said on Wednesday, page 134 of the transcript, that Abd-Al-Rahman participated in search and arrest operations, that he was present and gave orders for the arrest of a particular Umda, relying on uncorroborated evidence from 955, uncorroborated and indeed contradicted by prosecution witness 883. I'm going to finish by talking about murders briefly in the time I have left. I have 4 minutes left. This is important. It's a shame that I'm having to deal with this at the end, but there it is, chronologically, there we are. In their brief, and on Wednesday, the prosecution accused Ali Kusheb, Mr. Abd-Al-Rahman as Ali Kusheb, of directly murdering two men, Jenef, the man by the nickname, Adam, the man who has the nickname Jenef, and Adam, the same name as Jenef, but with the nickname Mota. We say that even if there is evidence that Ali Kusheb, taking the prosecution's case at its highest, even if there's evidence that he did strike both Jenef and Mota with an axe or a stick to the head, the evidence is insufficient to establish beyond reasonable doubt that these blows killed those two men. And in fact, the prosecution appears to concede as much at paragraph 548, that it's possible that they weren't killed at that time because they advance an alternative scenario in which they say it's reasonable to infer that they died after being transported to an execution site, either due to the absence of medical treatment for their injuries or because they were then shot. But there is not even firm evidence, we suggest, that the injuries to the heads of Genève and Mota went beyond what might be called actual bodily harm and crossed into the into the realm of serious bodily harm. There's evidence maybe that Genève lost consciousness, but I think I'm right in saying that there's evidence that he may have been on his feet some time later. There's no evidence that one or both didn't die by dint of an intervening event. They may have that if they died, they were shot by another person in authority, or another Janjaweed militiaman, or indeed killed at the execution site or an execution site under the orders of someone else. We simply don't know because there's no evidence. And we refer to our defence briefs at paragraphs 593 to 595. Quite apart from the fact that there are three witnesses who mention the striking of Genève by Ali Koucheb in three different ways at three different places at Delej police station, and another witness who says that Genève was actually killed at the execution site with the Umdas, that's P883. And as far as the murder of Mota is concerned, well, P907 is the only witness who mentions both murders. I won't say them because there are two witnesses who do not mention the murder of Sheikh Mota, and one other witness who does not mention the murder of Genève. There are four witnesses who were at Delej police station who don't mention either murder. Do I have time? Very briefly, last point, the executions. On Wednesday, the prosecution firmly and clearly set out their position. Regarding the evidence on the transport of detainees to the execution sites, our case is, and has always been, that there were several transports to multiple sites. But that evidence is simply flatly contradicted by the evidence of one of their star witnesses. If I describe him as the sees everything, been everywhere, hears everything witness, that evidence is that there was a single convoy, a single transport, one single occasion of 13 vehicles to a single site in Delej. And the prosecution don't explain why it is that, in terms of this witness, their choice is to ignore it. Your Honor, I was going to address persecution. That was addressed by Madame Matteo yesterday. I know that I'm going to get into a lot of trouble if I don't sit down now. Thank you for listening.
Thank you, Mr. Edwards. Mr. Lauchi.
À l'attention des interprètes, je lis mes notes et les rares fois où je m'en écarte, je ralentirai. Mon exposé de ce matin est en relation avec...
Regrettably, Mr. Lauchi, the fact that the interpreters have your notes does not mean they can read them out at the speed at which you are already starting to talk. They've still got to read them out. So you need, I appreciate you're worried about time, but
Extremely.
yeah. But don't forget, you said a lot in your final brief. And really what this is for is to amplify rather than to repeat. And as I say, don't worry about our questions because we'll deal with them separately. But you must slow down. They can't keep up.
Thank you, Madame President. Je commence par la ligne 1. Monsieur Abd-Al-Rahman n'est pas Ali Kouchaïb. Les mémoires du bureau du procureur et des représentants légaux des victimes s'appuient successivement dans leur démonstration sur diverses catégories de preuves. Certaines ont été répondues dans le mémoire, je n'y reviens pas, je m'adresse exclusivement aux autres. La première catégorie est la preuve testimoniale. Dans sa démonstration que M. Abd-Al-Rahman serait Ali Kouchaïb, le bureau du procureur s'appuie sur 4 témoins. P643, P874, P883 et P905. Les représentants légaux des victimes reprennent les mêmes et y ajoutent 10 autres. Nous avons discuté la crédibilité des 4 témoins que j'ai cités, je n'y reviens pas. Le seul témoin sur lequel rien n'a été dit jusqu'à présent est le témoin P916, qui est mentionné en note de bas de page 205 des représentants légaux des victimes. Je vais en parler. Avant ça, je commencerai par réfuter la suggestion formulée au paragraphe 8 du mémoire du bureau du procureur, selon laquelle la défense ne serait plus en position de contester que M. Abd-Al-Rahman porte le surnom Ali Kouchaïb, parce qu'elle n'aurait pas soumis aux témoins qui le prétendaient que son surnom était en réalité Abou Nasser. Il est bon que le procureur se souvienne de cette règle, il ne peut donc prétendre l'ignorer, mais cette règle est sans pertinence pour ce que le bureau du procureur essaie d'établir. Le surnom Abou Nasser est une question distincte, sans rapport avec l'alias Ali Kouchaïb. La défense a systématiquement confirmé, contesté l'affirmation des témoins selon lesquels Ali Kouchaïb serait M. Abd-Al-Rahman, et elle le leur a fait savoir dans les termes les plus clairs afin qu'ils puissent justifier de leurs preuves sur cette question. La défense a donc scrupuleusement respecté la règle fixée par la Chambre et continue d'être fondée à contester l'alias Ali Kouchaïb. En ce qui concerne le témoin P916, il a précisé ne pas connaître personnellement Ali Kouchaïb, mais avoir entendu parler de lui dans la rue, sans plus de précision. C'est le document 64 dans la table des autorités. Le témoin P916 ne fait donc que rapporter un oui-dire, anonyme, non daté, comme base de sa connaissance d'Ali Kouchaïb. Aucune valeur probante. Le bureau du procureur, d'ailleurs, ne s'y est pas trompé, il ne s'y réfère même pas. Enfin, les représentants légaux des victimes s'appuient sur le contre-interrogatoire du témoin D32, dans lequel il mentionne avoir entendu parler pour la première fois d'Ali Kouchaïb en 2003-2004 à Garcilla, et tout le temps depuis. Il n'aura pas échappé à la Chambre que le témoin D32 présentait des capacités de compréhension limitées et a été plus que confus tout au long de son témoignage. Ainsi, vous vous référez au passage du document 84 dans notre liste, le témoin D32 a prétendu avoir entendu parler du mandat d'arrêt à l'encontre d'Ali Kouchaïb en 2001 ou 2002, quand la Cour n'existait même pas, pour finalement conclure qu'il ne se souvenait pas quand il avait entendu parler de ce mandat d'arrêt et de dire qu'il en avait entendu parler dans les médias. Médias qui ne faisaient que diffuser les informations en provenance de la Cour. La seule conclusion raisonnable que votre Chambre pourra tirer du témoin D32 est qu'il ne se souvient pas de quand il a entendu parler d'Ali Kouchaïb pour la première fois. Mais ce qu'il y a de commun entre P916 et tous les autres témoins, et la quasi-totalité des témoins sur lesquels le bureau du procureur et les représentants légaux des victimes s'appuient dans leur mémoire, est le fait qu'ils ont été interviewés par le bureau du procureur après le 27 février 2007. C'est-à-dire après que le bureau du procureur a rendu public et largement diffusé les informations suivantes. Première information, Ali Kouchaïb se nommerait en réalité Ali Mohamed Ali Abd-Al-Rahman. Deuxième information, Ali Kouchaïb aurait porté le titre de Aguid al-Ogada. Pièce numéro 1, paragraphe 36. Ali Kouchaïb serait âgé d'environ 50 ans en 2007. C'est la même pièce, paragraphe 37. Ali Kouchaïb serait de la tribu Taïcha, même paragraphe. Ali Kouchaïb tiendrait une pharmacie vétérinaire à Garcila, c'est le paragraphe 203. Ali Kouchaïb aurait été employé en 2007 comme assistant de police au Darfour Ouest, c'est l'annexe 12 du document 1 au paragraphe 4. Ali Kouchaïb aurait été arrêté le 26 novembre 2006, même paragraphe. Et Ali Kouchaïb serait encore en détention en février 2007. C'est le paragraphe 276 du document 1. Comme vous pouvez le constater, nul n'est besoin d'une conspiration pour fabriquer la légende Ali Kouchaïb. Seul le bureau du procureur et les représentants des victimes, d'ailleurs, utilisent ce mot. Et la défense, quant à elle, n'a jamais utilisé le mot conspiration et le réfute. De même, hier, la distinguée représentante légale des victimes a suggéré que la défense ferait un parallèle avec un précédent devant le tribunal pénal international pour le Rwanda. J'ignore à quoi ma collègue se réfère et je réfute cette interprétation. Je n'ai jamais entendu parler de fabrication collective de mémoire dans le cadre du tribunal pénal international pour le Rwanda et je pense qu'il ne fait aucun doute possible que le génocide rwandais a bien eu lieu. Nul n'est besoin d'une conspiration, donc nul n'est besoin d'un soi-disant précédent rwandais dans notre affaire. L'action du bureau du procureur suffit, relayée par les médias, à créer la légende Ali Kouchaïb et à lui donner corps avec les 9 informations que je viens d'énumérer. Cela signifie que, en disant à la Cour que Ali Kouchaïb est M. Abd-Al-Rahman, et en se référant à l'une ou l'autre de ces 9 informations, la totalité des témoins, sans exception, ne font rien d'autre que répéter l'information rendue publique par la Cour et largement diffusée par les médias, en particulier les médias soudanais. Disent-ils la vérité ou ne font-ils qu'adapter leur témoignage à la cause du bureau du procureur? Vous ne disposez pas, mesdames les juges, vous ne disposez d'aucun moyen fiable de le déterminer. Le bureau du procureur, par les informations qu'il a inutilement rendues publiques le 27 février 2007, a sapé la fiabilité de sa propre preuve. Quand bien même vous seriez encline à considérer qu'un témoin semblait crédible, un doute raisonnable subsistera qu'il n'ait en réalité fait que répéter les informations qui étaient diffusées dans les médias et qui trouvaient leur origine dans l'action du bureau du procureur. Avec ce précédent, la preuve testimoniale devient d'aucun secours et devra être écartée. Le deuxième élément de démonstration sont les divers éléments de biographie, réels ou allégués, que M. Abd-Al-Rahman aurait en commun avec Ali Kouchaïb. Le bureau du procureur s'y réfère pour dire qu'il s'agirait en réalité d'une seule et même personne. Alors, comme je viens de l'indiquer, les informations selon lesquelles M. Abd-Al-Rahman et Ali Kouchaïb seraient Aïcha, auraient porté le titre Aguid al-Ogada et auraient tenu une pharmacie sur le marché de Garcila, qui est d'ailleurs situé à proximité de la Banque agricole, étaient largement connues, diffusées dans le domaine public à partir du 27 février 2007. La Chambre ne peut pas s'y fier raisonnablement. Une fois l'information que M. Abd-Al-Rahman ou Ali Kouchaïb sont de la tribu Taïcha, diffusée au public, l'information selon laquelle les deux seraient originaires de Raad el-Baldi ne constitue rien d'autre que la conséquence naturelle de cette information. Raad el-Baldi et sa région sont le Dar, le territoire d'implantation de la tribu Taïcha. Cette information n'a donc aucune valeur probante. La preuve sur laquelle le bureau du procureur s'appuie en note de bas de page 170 ne dit pas d'ailleurs qu'Ali Kouchaïb est Taïcha. Le témoin P12 prétend qu'Ali Kouchaïb serait Rizégat. Le témoin P119 dit qu'Ali Kouchaïb serait d'une tribu non arabe. Et le témoin P932 ne dit rien sur la tribu d'Ali Kouchaïb. En note de bas de page 171, le bureau du procureur s'appuie, entre autres, sur les déclarations du témoin P1021. À l'appui de l'information selon laquelle M. Abd-Al-Rahman et Ali Kouchaïb auraient servi dans le service médical des armées en tant que moussaïd. Mais le témoin P1021 ne dit nulle part cela dans son témoignage. La référence est erronée. L'information fournie par le témoin P874 est que Ali Kouchaïb aurait été dentiste. C'est la pièce 70. Ce que M. Abd-Al-Rahman, naturellement, n'a jamais été. P874 répète également l'information erronée relative à la pharmacie vétérinaire. Les témoins P907, P931 et P984 ne disent non plus nulle part que Ali Kouchaïb servait dans le service médical des armées. Les références des notes de bas de page 171 sont encore erronées. Les témoins P931 et P984 mentionnent tous les deux l'information erronée relative à la pharmacie vétérinaire. La Chambre ne peut pas non plus se fier à leur témoignage. Et la défense renvoie finalement à ses soumissions sur l'absence de crédibilité des trois derniers témoins, P643, P878 et P883. L'information relative au service de M. Abd-Al-Rahman ou d'Ali Kouchaïb au Soudan du Sud constitue la conséquence logique de l'information précédente relative à son service dans les forces armées. La génération de M. Abd-Al-Rahman et celle 10 ou 20 ans plus jeune de Ali Kouchaïb ont en commun d'avoir exercé l'essentiel de leur service militaire au Soudan du Sud, qui constituait la principale zone de conflit dans laquelle le Soudan était engagé. Cette information, encore, ne peut servir de preuve concluante de l'identité entre les deux personnes. Le seul témoin P883 sur lequel le bureau du procureur s'appuie en note de bas de page 172 à l'égard d'Ali Kouchaïb, parle d'ailleurs d'une expérience de combat et de commandement au Soudan du Sud, ce qui est incompatible avec les fonctions attachées au service médical de l'armée, ainsi qu'en ont attesté les témoins P643, c'est la pièce numéro 56, P883, c'est la pièce 63, D07, pièce 85, D16, pièces 79 et 80. Le témoin P883, vous l'aurez noté, donc se contredit à nouveau sur ce point. Il parle en même temps d'une expérience de commandement et de combat, tout en disant que Ali Kouchaïb était dans le service médical, ce qui est incompatible. Contrairement à ce que le bureau du procureur prétend en note de bas de page 175, l'information selon laquelle M. Abd-Al-Rahman aurait habité dans le quartier ouest de Garcilla en 2003-2004 ne fait pas partie des faits admis avec la défense. Nous ne parlons que de Garcilla, certainement pas du quartier ouest. Le témoin D32, lui non plus, n'a jamais mentionné le quartier ouest. Il ne parle que de Garcilla. Les deux seules références du bureau du procureur sur ce point, concernant M. Abd-Al-Rahman, sont donc erronées. Le témoin P643 ne mentionne pas, lui non plus, la zone dans laquelle vivait M. Abd-Al-Rahman ou Ali Kouchaïb. La référence du bureau du procureur est encore erronée. La défense renvoie à ses soumissions sur l'absence de crédibilité des témoins P643 et P905 et renvoie au paragraphe 698 de son mémoire en relation avec le témoin P11. J'en viens au bâton ou à la hache, le fameux fahar. Cet élément est dénué de la moindre signification. Ce point est adressé aux paragraphes 732 et 733 du mémoire de la défense. Les témoins P129, pièce numéro 65, et P883, pièces 61 et 109, ont indiqué qu'il s'agissait d'un accessoire d'usage commun au Soudan. Aucun des témoins visés par le bureau du procureur en note de bas de page 177 ne se rapporte à M. Abd-Al-Rahman. Tous ne font que parler d'Ali Kouchaïb. L'information relative à la maison de Niala, au contraire, elle, ne concerne que M. Abd-Al-Rahman et jamais Ali Kouchaïb. Les autres témoins qui lient cette maison de Niala à Ali Kouchaïb ne sont pas crédibles. Le témoin P874 parle d'un cabinet dentaire, pièce 70. Et la défense a justifié des raisons pour lesquelles il n'est pas crédible. Les raisons pour lesquelles le témoin P769, qui ne connaissait même pas M. Abd-Al-Rahman, n'est pas crédible, sont également dans le mémoire de la défense. Quant au témoin P921, sur lequel le bureau du procureur s'appuie en note de bas de page 178, il ne mentionne pas cette information. La référence est manifestement erronée. Enfin, le bureau du procureur se réfère au paragraphe 57 de son mémoire à un poème enregistré sur l'un des téléphones en possession de M. Abd-Al-Rahman au moment de sa reddition. En anglais, c'est la pièce 154. Ainsi que l'indique le bureau du procureur, il aurait été enregistré en mai 2010, soit à une époque où le lien entre M. Abd-Al-Rahman et Ali Kouchaïb était déjà dans le domaine public grâce à l'action du bureau du procureur depuis 3 ans. Ni l'auteur du poème, ni la personne dont la voix est enregistrée ne sont identifiés. L'enregistrement de ce poème s'analyse dans le meilleur des cas comme la déclaration d'une personne tierce, non identifiée, et qui n'a pas pu être interrogée comme témoin pour authentifier et expliquer son contenu. Ce poème ne revêt donc aucune valeur probante et doit être écarté en vertu de l'article 69, paragraphe 4. J'en ai fini avec les correspondances biographiques. Aucune ne permet donc raisonnablement d'établir un lien entre M. Abd-Al-Rahman et Ali Koushaïb.
Well, that, Mr. Lightshave, that's, if you finish that topic, then that's probably an appropriate time to break.
I would not have proposed better.
Right. All right, we'll break.
Maybe, if the time is not counted for that. I may answer your question regarding the statement of Mr. Abd-Al-Rahman.
Yes, that'd be helpful.
I thought about, I tried to do better than yesterday evening. What I can say more is that Mr. Abd-Al-Rahman has been warned that if he takes the floor, he is waiving his right under Article 67(1)(g. And, of course, what he may say may be used against him. I don't know if that answers your question.
But it doesn't. But I think it's one of the few aspects of trial procedure where there still is a divide between those who come from the same system as Mr. Edwards and those who come from the system that Judge Alipini comes from, and yourself. And as far as what troubled me yesterday, because it is the first time that I've come across this particular aspect, because it didn't exist in ICTY by and large, is how we were supposed to deal with it. But it seems to me, when I reflected overnight, that the best way you can look at it is if it's not evidence, it's argument. And as you say, you've warned him that he's waived his right.
That has been done for sure.
Yeah.
And I defer to your legal authority for the aspect that you just mentioned.
Well, I mean, that's the best way I can see of dealing with it. It's part of the final address, if you like.
There will be no challenge against
Right.
that construction.
Yeah. All right. Thank you very much, and we'll adjourn until 11:35.
All rise. Veuillez vous lever.